All right. Welcome, everybody. This is Andy Yost with the Capacity Building Center for Courts. We're here for our June ICWA constituency group meetup. Today's topic is peacemaking as an active, it's about peacemaking, and then the broader question that initiated this conversation is, has anyone had experience using peacemaking as a kind of active effort? So we'll hear a little bit today from our creator, who is a tribal court judge in Alaska. I'm going to let Scott do the formal introduction, Justice Fairbanks, in just a minute. So we're excited to have the judge with us. So he'll do a presentation on peacemaking, and then we'll have an opportunity to jump into the lunchroom and have a conversation about the work that you all are doing, if any, around peacemaking, or the questions that you might have for each other or for our creator today about peacemaking. So before we do that, let me do a real quick roll call. I'm just going to read. I haven't done this before, but I have heard a lot of clicks on the phone. I want to see if I got everybody in the room as well. I'm going to read the names off that are on the participant list in the Connect room. And then if you're on the phone and I don't read your name, will you just introduce yourself? So I see Amanda Doctor, Ashley, Cindy Bricker, Jill Holt, Michelle Zachard, Morgan, Sarah Jacobs, Stephanie, Tina, and Veronica, all in the room. Is there anyone whose name I did not read that's on the phone? Great. And then Justice Fairbanks, are you on the line as well?
Yes, I am. This is Cheryl.
Great. Hi. So hang tight for 1 second. I'm going to get this group just oriented, and then we'll jump into the presentation. So thanks.
Okay.
All right. So look, everyone that's in the participant list these are our usual suspects, which is good. So you all know how to use a Connect room. So I'll do a real quick flyby. We have a slide deck in front of us. We'll use that as a placeholder, and then when Justice Fairbanks does her presentation, she'll have some materials to share with you. In the lower left-hand corner is our agenda and phone number and some instructions on muting. The middle center of your screen is the chat box. Lower right-hand corner is the ICWA Resource Exchange, which is the compilation of materials that we've collected over the last year or so, sharing in our peer-to-peer network. And then right above that is a pod that says Peacemaking Resources. Those are 3 resources specifically on peacemaking, and actually one of the articles, the one Exit Pursued by a Bear, is written by a state court judge who's integrated some peacemaking efforts into state court practice, but also references Justice Fairbanks' works as well. So I recommend that read in particular. If you only get to read one of those 3, that one I really enjoyed, although all 3 of them are good. Those resources were given to us by I'll see if I can pronounce her last name, Beth Gilia, I believe, from New Mexico. Although, and Sarah, you'll have to correct me in the chat if I'm wrong about that. She actually was the person who raised the question of peacemaking in our last meetup, but then had some press of other business that kept her from meeting with us today. But she wanted to be sure to share those 3 resources with this group. So, and Gilmore a couple months ago asked if we could start separating out the materials into a separate files pod that has just the materials that we're working with today. So we've done that. And that's in the Peacemaking Resources files pod. If you want to download one of those files, you just click the file and then hit download file, and it'll drop it into your computer. Or you can click the little drop down icon in the upper right hand corner of the Peacemaking Resources file pod and just hit download all, and it'll drop all 3 onto your computer. And then, of course, in the upper right-hand corner is your attendees list. You can just hover over someone's name if you want to have a private chat with them. That chat truly is private. I don't see it. Scott doesn't see it. No one sees it. And it's not recorded or preserved. But the group chat with everyone in it, that chat is preserved. So make sure that if you have a question or a brilliant idea or suggestion or want to make a connection with the broader group, type that into the chat so that we have a chance to see it and can read it. So, all right. So that's the orientation. Let's do a real quick test of the chat. I asked a question earlier, and it looks like most, but not everyone responded to it. So let's try to, again, get 100% response. We're heading into 4th of July weekend. The question that I want you to answer by typing into the chat is, what picnic food are you most looking forward to eating on 4th of July? So I'll set my timer for 60 seconds. Take 1 minute and just type that into the chat. This is just sort of a silly and fun way to make sure that everyone's tuned in and their chat functionality is working. So what picnic food are you looking forward to eating on 4th of July? You're never one to disappoint, Scott. Yeah. Scott, what is that? Is that I assume it's Indian food, although I don't actually know that. What is that? We get a type response. Good. Okay. Okay. Yeah. Sounds nice. Corn and tomatoes, that's where my heart is right now for sure. And Veronica, I know you know as well as I do that this time of year is best in Ohio for corn and tomatoes, so we're all eating good. All right. It looks like everybody's got their chat functionality up and running, which is great. So what we'll do now is we'll move into our creator section, and Scott, I want to say a couple opening remarks about our presenter, and then we'll go from there.
Yeah, when the topic of peacemaking came up last call, I recalled talking to Gina Jackson, who had been staff that had worked on the predecessor to the Capacity Building Center for Courts with us, and she's now at the National American Indian Court Judges Association. And I just, I talked to her before about that, and I said, I know they've worked on that. So she introduced me over email to Justice Fairbanks, and a comprehensive introduction of Justice Fairbanks relevant to Indian child welfare would probably take a lot of time, but some highlights I would note are that before going to law school, she was a public teacher in New Mexico. She's worked on ICWA for many years and developed some of the resources we've talked about on these calls before, including working on the NCJFCJ bench cards. She started at the New Mexico Indian Law Clinic that is very well known in this area. She serves as a justice with the Intertribal Court of Appeals in Nevada, and she teaches classes on ICWA and peace circles at Lewis and Clark Law School. And I'm sure she can add anything else that's relevant. But thank you very much for joining Justice Fairbanks and sharing your knowledge with us.
Okay, can you hear me?
Yes.
Okay, good. Good morning, everyone from Oregon, and a special thank you to the ABA and Court Improvement for having the Peace Circles on, and of course to Gina Jackson with the Tribal Courts Initiative. And I'd like to just go ahead and begin with the PowerPoint. And one of the things that I challenge everyone is to shift, and that is look at peace circles as an option for strengthening our justice systems in America. And so we developed this shift, how do you think about it, shifting from an adversarial to a resiliency model. And we wanted something that was spiritual, where we could create sacred space so everyone has a chance to speak. And, of course, silence is also okay. And something that is very holistic, healing, and really moving toward health, wellness, and restoration. Something that is issue-focused, where we're gentle on the person and tough on the issue, where we're able to really bring in our indigenous wisdom and our Indian core values. And of course, you've always heard of the Indian problem. Well, we believe it can be the Indian solution. And where there's facilitated discussions involving family, and for Native people, extended family is very, very important. and where we're able to tap into the community, and it's focused, and there's fundamental fairness, and then it really allows for redirection and a transition to change and transformation where time is really honored, and we really use a team approach. This is the first time I've used this, so, okay, there we go. And so in Native America specifically, how can, we've had to really look at how can we change the following statistics. And our domestic violence, physical and sexual assault are really 3.5 times higher than the national average. And that number may be low because many of the assaults are not reported. Also, our children are very much overrepresented in the care of Child Protective Services, and our education statistics are pretty dismal, as you can see on the PowerPoint. And many of our people live in poverty, 26%, and sometimes on the reservation, we have double the unemployment rate of the general American population. And so I know many of you are working on ICWA. It's an old law, old pattern, same story. And that's after 39 years, we have some of the same statistics as we had initially. And that is the out-of-home placement of our kids. Those placements are significantly higher, and many of our kids are still being placed in non-native homes. And so that has really caused the breakdown of our families, and the cycle of ICWA and removal can really be seen as some of the reasons for the number of child abuse cases and domestic violence incidences. And so is the adversarial system really working on reservation or off reservation? And many of, the life for Native Americans, many have adapted so that many of us are healthy and economically self-sufficient, but yet there's a big portion of Native American people who are not doing well. As you can see by these statistics, 26,000 are in U.S. jails and prisons. And what is interesting is I'm from Alaska, I'm Tlingit-Tsimshian, but I make my home in New Mexico. But if you look at the statistics for incarceration in Alaska, Native Americans make up 16% of the general population, yet they're 40% in prisons. And so when you look at the female population during 1996 to 2000, for non-Indian females, that rose 26%. But for Alaska Native women, in particular, it rose 41%. And really, what is happening to our kids? What is happening to our families and communities? And so we have to look at justice. And when I looked at the statistics for Native Americans, they were, of course, deplorable. But also, I wanted to recognize that in America in general, we're graduating too many kids out of foster care and in adoption scenarios where they have no ties to their family or to their respective communities. And so American justice is in crisis. We look at the statistics generally, and 2 million inmates are in local, state, and federal prisons. 7,000 youth are behind bars. 600 youth are behind bars just for status offenses. And these are the statistics with regard to our state prisons, federal prisons, juvenile correctional facilities, and the local jails. Now, and then of course 79 Indian country jails. Scott, are you hearing me okay?
Yep.
Okay, good. And so should we continue doing more of the same? That was the question we really had to ask ourselves in Indian country. Because doing more of the same but expecting different results, of course, we know that's the definition for insanity. Therefore, the challenge to shift, to really shift from the limitations of an adversarial system to something that is really more holistic and healing. And as a tribal lawyer and a tribal justice, I really use these 5 guiding principles that I'd like to share with you, and you see them listed. We've been facing the wrong way, especially as a Native American community, and we have to understand the federal policies and the impact on Native America, and understanding the significance of oral tradition and the Native American language, and re-educate the educated, and then the call for consensus, collaboration, comedy, and unity. And I'll go into each one of those separately. And so when I say we've been facing the wrong way, as Native Americans, we've really been a replication society. We've just carte blanche adopted federal and state models. And we love the be like. We're going to be like the state model, be like the federal model. And our tribal courts have been strongly criticized for this, as stated in a law review by Samuel Brackle. And he said, the tribal courts are really nothing more than a pale replication of American justice. And when I saw that, it kind of made me angry. And then I really had to do a reality check, and sure enough, we were just replicating the outside, and that really wasn't working for us as Indigenous people. And so I knew we had to turn around and shift, where we place value on our ways, our traditions, our culture and way of life, and so that we could look for the answers within our respective Indigenous communities, and we could draw upon our own values and our traditions and customary law in a contemporary context. And that's where the challenge is how can we do this in a contemporary context? And so I really looked at universal Native principles, and those are borrowed from different tribes that I've worked with throughout the country. And that really brought us to common ground of how can we bring these core principles into a contemporary court system. And you can see those up there on the slide. I wanted to share with you, these are core values that my class, the fall of 2015, came up with. And I really thought they really did a lot of soul searching, because they weren't into shifting. They were really into the adversarial method, and it really took them some time to shift into working in a peace circle session. And so they brought up integrity, being true to your word, not only with clients, but with colleagues in the court, diligence, hard work, go the whole distance. Warrior spirit is really borrowed from and maybe you've seen this film. It is a short documentary on We Shall Remain. It's only 7 minutes, and I encourage you to look at it. You can get it on YouTube. But their warrior spirit was really defined as be brave, confident, persistent in your representation, stay balanced and happy, be resilient, and adapt. And probably the one principle that has worked, especially in Indian country, is the universal law of respect, where we affirm others' goodness and we are positive and empathetic. And of course, the last one is humility in terms of being authentic, and really working to resolve conflicts in a way that we are preserving relationships. And in Indian country, that preserving relationships is absolutely critical. These are individuals who have shifted. Judge William Johnson is on the left, and Judge Monica, he's a tribal judge, and Judge Monica Zamora is on the right. She's a Court of Appeals judge. And they swore in the class. They really work at relationships, and they co-chair the State Tribal Consortium for New Mexico. And these are the students who they're swearing in. And these students actually use the peace circles in federal, state, and tribal courts in New Mexico. And they also presented to the New Mexico Judicial Consortium. And they borrowed from the teaching of the seven grandfathers, which are Anishinaabe and Chippewa up in the north. And Judge Patowski uses these. He's a judge in Michigan, and he works closely on state tribal relations. And he's brought these teachings and core values into the state and tribal court system, you can see. And the National Council of Family and Juvenile Court Judges did a peacemaking, and that is kind of small. But those are the values that we came up with, and they pretty much mirror the ones that I showed you before. So the point being that we can find common ground through our core values. And so understanding the second rule or principle I use is understanding the impact of failed federal policies. And usually we have, as Native people, been impacted by deliberate federal policies that serve to assimilate or terminate us as a people, as tribes. And those are most likely the people before your court. They've been impacted by these policies. And here are the policies. They're really clothed in removal, assimilation, and termination. And you can see they were deliberate, and there has been major impact to our communities. Each and every one of us has been impacted by those policies. And the policies, this is the time period, and often they're thought of as historical policies, but these policies have really had an impact on the generations in the lifetime of my grandmother, my father, myself, my children and grandchildren. And so the point being is, let's not replicate them. Let's stop and really work on policies that serve to preserve culture and serve to allow for an indigenous voice to be heard. And this speaks for itself. You've probably seen this before. This is the removal of children to boarding schools, but the removal now is really the Indian Child Welfare Act, as you know by the statistics. And so the third principle I really use, especially for peace circles, is really understanding the significance of oral tradition. And as a tribal lawyer, I want everything written. I want pieces of paper. I want the law. So I really had to shift to realize that really the oral tradition through our native language really brings in our cultural viewpoint and our custom. And it allows us to value our elders, and it allows us to bring the distinct, unique law of each tribe. Because one of the mistakes America makes is putting us all in this melting pot when in fact we are all different. And so understanding the oral tradition is an important piece. And my dad always said, if we have our native language, we will always have the custom and tradition of our tribes. And under UNDRIP, I really looked at the international law And it states that Indigenous people really have the right to be heard and understood in their own language in a different setting, as, for example, in court. And so the Indigenous concepts related to traditional dispute resolution is really based on a holistic philosophy, unwritten customary law, traditions, practices, oral teachings that come to us in a circle of justice and connects everyone with the problem, so everyone is focused on the same center. And Professor Christine Zuni-Cruz reaffirms that this law sometimes is oral, passed from generation to generation, and it may not be entirely accessible, but it is internal and oral, and for the most part dynamic and not static. And so moving to the fourth principle is re-educate the educated, and that really means that we have to pause and rethink our processes, because education was really the way to assimilate us into the greater society. We don't take it for granted. Today we use it as our greatest tool for the protection of strengthening our tribal sovereignty and protecting our kids and communities. And really our charge is never to replicate those past termination and assimilation policies that I shared with you earlier. And so in shifting, we really want a call to consensus. And consensus is very much valued in an Indian community because an adversarial methodology can really polarize a whole community, a whole family. And so we really like the consensus model in terms of bringing agreement and collaboration. And comedy in peacemaking really means courtesy, considerate behavior, stability, mutual respect, and it's based on the universal law of respect. And of course, moving toward unity. And American justice is in crisis, but and so many courts are looking toward traditional dispute resolution. And for us, the peace circles are really a way of life, and we had to look at it because whenever you have a continuing relationship, you have to do something different, and we recognize that early on in our work in the tribal courts. And so it's really not mediation. It is a formal process. It can be a division of the tribal court. And I'm going to share some different models. And through the process of oral tradition, we are recording the community voice of the Choctaw people by developing a library of indigenous law. And at Choctaw, they really had a lot of discussion. Do they want a peacemaking court to be a division? And they were unsure, so they looked at other tribes, and they decided to name theirs the Itikana Ikbi, which is the peacemaker, the peacemaking process. And their Itikana Ikbi is established by tribal ordinance as a separate court. And the peacemaker there has to be from the community and has to know the tribal language. And so the focus is on process, making things right, repairing, talking things out. Prayer is used. They use the customary and traditional law. No attorneys. Talk is necessary. Native language is used. There's no time limit. The community right may supersede the individual right, like we see in ICWA, where the tribe has a say into the placement of children. Apology and forgiveness are very, very much valued, and when it's completed, it is completed. And so when you look at Choctaw and Native American core values and American justice, Choctaw Okla really focuses on community, and America focuses on individualism. And Itibaka Chapa focuses on cooperation and collaboration, where the American system is really on competition and winning, the win-lose model, And the Iti Halalia focuses on relatedness and the importance of relationships and the connection, where the American model really focuses on autonomy. And so in Choctaw, they knew that they had to do something different because it was a way to put some of the people's thinking, the community values into their system. This is a chart I use in my class and when we're doing actual peacemaking, and the procedure on the left, on the column on the left is the procedure and the column on the right are the rules. And the rules really go to the rule of respect, speaking with care, listening is very valued, consensus is important, passing is okay, and we added one, and that is agree to disagree. Because often in peacemaking, people get the wrong idea that we don't have to agree. Oh dear, that we have to agree for everything. Scott, how am I doing on time?
I think we're 15. I'm sorry, I didn't look at exactly when you started, but yeah, I think we're probably more than halfway through.
Okay, good. So I wanted to share other tribal peacemaking models, and the ones on top are really models where there's written codes, and the two on the bottom, the Cocha de Pueblo and Taos, they are really unwritten courts, and they really are probably the most authentic in terms of traditional and customary law. This is an example of a code where they focus on harmony, relationships, consequences, consensus. And these are goals of the Seneca Peacemaker. And you can see they're goals that any court in the country would want, protecting their sovereignty, rendering decisions. And I think the important piece is not just for the individual, but for children, families, and the nation. And of course, the fundamental fairness and equity. And another example is the Ho'oponopono in Hawaii. And it really mirrors our peace circles process, where they start with prayer, they go over the issues, and they recognize that the injurer and injured are bound together by doing and blaming. And I love their Ho'omalu, put it in the shade, where they take a recess, and we've added that to our process. And of course, the injurer and injured must be released, for each feels the pain of the other. A lot of focus on forgiveness and where the wrong is separated from the person. We call that be gentle on the person, tough on the issue. And then the pule, the prayer of completion. And so our peacemakers usually come from the community, those who are knowledgeable in the customs and traditions of the tribe, and they act as judges or officers of the court. They have the authority to use tribal cultural teachings, and of course everything is voluntarily to be before the peace court. And it's a consensus model. Often we have legal counsel review the agreement if they want, and then we have a 10-day reconsideration so that in case we miss something or something needed to be corrected. And these are the kinds of disputes. As you can see, they range both in civil and criminal, and we're getting a lot of success in all areas. And that's the basket, one of the baskets that we use, and the basket is really the weave of tribal sovereignty, and you can only speak in the circle when you're holding the basket. And I use this technique with the federal mediators from the 12 circuits. And I just didn't think the mediators and peace circle people could come together. But the common ground we found was, of course, the circle and the basket. They really like that in terms of keeping your circle in order and respecting everyone. And each person is part of the weave and important to the whole. You are the design. Your input is necessary. Without your part, it's incomplete. And that basket really represents sovereignty in our custom and traditions. And so the power of the circle, of course, this is done in a circle. Everyone is seated in a circle as equals, and in that circle, everyone becomes united. It has no beginning or end. The energy forms to build resolution, and face to face, it allows for a shift, and it allows for a sacred space to be developed, so people are really open to sharing and building resolution. And so Michigan shifted, and I'm going to share the Washtenaw Court with you. They borrowed relationships, responsibility, respect, and redirection from tribal court values, and they put it into their state system in 2013. And they created this model to replace the limitations of the adversarial system so they could really heal relationships and restore the individual within their family and community. And of course, they integrated those 4 core values and used them as a means of resolving conflict and returning balance and harmony into relationships. And their training is done at their dispute resolution center, and they have agreements, compacts that are binding as a contract. And these are some of the statistics. 94% of the cases resulted in an agreement from both parties. And you can see 94% also agreed that they would recommend peacemaking to others. Those are good statistics. And I looked at UNDRIP again, and in UNDRIP, really the rights of Indigenous people, conflict resolution processes should respect the Indigenous rights, customs, and legal systems, and I think shifting to human rights. And I think often when I view the child protection system, it really sometimes looks more criminal in nature, and we really need to shift to something that really promotes human rights and restoring of relationships. And in ending, I really wanted to just share some of the Indigenous voices. Peacemaker Henderson was one of our first peacemakers of Mississippi Band of Choctaw. He always was, let us make peace. Judge Blytheway just said tribal courts are really important to the community and to nation building and their mechanisms to make peace. And these are peacemakers where we convened at UNM School of Law. This is just Chief Justice Yazzie, Chief Justice Emeritus of Navajo, and he really uses the concept of ke, which means respect, to restore dignity and worthiness. And even our Supreme Court justices of the U.S. Supreme Court in Holyfield have deferred to the experience, wisdom, and compassion of the Choctaw tribal courts. And we want to do something different for the sake of the children. And Chief Justice Kevin Briscoe really focuses on affirming a therapeutic model such as peacemaking, because our Native youth will be our upcoming leaders and the ones to carry the torch. And we need to use our tribal values and traditional laws. And that is affirmed under UNDRIP, in that children of an Indigenous group may not be taken away from their family by force. And this is one group that I wanted to share. The woman in the middle with the necklace and the beige shirt is pre-ICWA, and these are her true bio aunts. And she was adopted by non-Indian people at birth, and she wanted to reconnect with her family. And our first reconnection was a total disaster. Then we brought Jay in. Jay is the boy and man in the blue shirt, and he speaks Navajo, and of course he's got his Juris Doctor. We used the peacemaking to bring this family together, and the aunties are very older. They're in their 90s. And they embraced her. She connected with her family. She got enrolled in the nation. And that just served to show how important peacemaking was to the process. Now, Jay was not a believer in peacemaking. He has been schooled in the adversarial method like a lot of us. And he even told me he needed to go to therapy to learn it and understand it because he had been working so hard in the adversarial. So I just wanted to share that story. And in Alabama, Coshada, we used a forum to share our ideas. And these are peacemakers, judges. And the peacemaker on the left is a senior peacemaker for Alabama, Coshada. On the right is Judge Byrne, who is the former president of the National Council for Family and Juvenile Judges. And Casey Foundation gave them these baby blankets so they will always remember ICWA and to really comply with ICWA. And you can see the peacemakers in the background who have shifted. And so I challenge you to sovereignty begins at home. There's a lot we can do at home prior to litigation. And you can make the difference. You can create the ripple effect. And I wanted to share this picture with you of peacemakers who we convened in at Lewis and Clark and had a ICWA peacemaking colloquium. And you can see they come from diverse backgrounds from all over the country. I'm the one in the middle with the turquoise scarf, and you can see judges from tribal courts as well as the state court. And the Washtina court is really the gentleman in the last row, 1, 2, 3, 4 in, and he's the one who developed the Washtina model in Michigan. Brett, 2 over with the glasses, is NARF, a NARF attorney, and we have a community of peacemakers that he brings together. That's all of us here. Gia Jackson, who got me connected to this group, is the one in the blue suit coat on the left. And these judges and jurists have really shifted to a peace circle as an option for strengthening ICWA cases as well as for justice systems. So that was a brief interview and presentation. In my language, I say Gunesh Chish, which means thank you, and Gunesh Chish Ho Ho means a very big clink at thank you. And so that concludes the presentation.
Great. Thank you very much. Really appreciate it. I have to say, I was chatting with Scott in a side chat while you were presenting and found this topic really fascinating. My own selfish reasons, which is that I'm non-native, but I have been doing a PhD in philosophy and religious studies and have worked with a couple of indigenous scholars, one Dr. Tink Tinkers and Osage, and he really kind of put me onto this idea of decolonized methodologies. And I've been thinking hard I'm also a lawyer, I've been thinking hard about how we might integrate indigenous practices into our work. And so you've directly answered that question, and I really appreciate that. Scott, is there anything else that you wanted to say or follow up with before we move into the lunchroom Q&A session?
Well, are we bringing up the Q&A if like the active efforts hook is there, or is that to be brought up before?
I had planned on sort of just wrapping the Q&A session and any questions folks have about active efforts specifically or peacemaking more generally in the lunchroom.
Okay. Yeah, I don't have anything then.
Okay, gotcha. All right. So now what we'll do, folks, is we'll meet around the lunch table here as we have this running metaphor with our group that we are a lunchroom, not a boardroom. And the idea there is just that we're trying to promote sort of an informal peer-to-peer sharing space where we can toss ideas back and forth, ask questions of each other, and learn from each other without having a hierarchy or any kind of sort of strict rigor about it. So we normally put up a goofy picture to symbolize some kind of eating space in the middle, and then we're all sitting sort of in a circle around that lunch table. So with 4th of July coming around the corner, I thought I'd throw a juicy hamburger, some health food up there for all of us to stare at while we have some time together in the lunchroom. So let's start with a little bit of an open space. What questions do folks have for Justice Fairbanks about her experience, anything that she said, or peacemaking in general? I'll leave a 90-second window here for folks to ask questions, and then if people have questions, we'll stay on this topic as long as we need to. I see some folks typing into the chat already, and if you'd like to ask a question over the phone, feel free to just jump on the phone as well. Gotcha. I see Michelle's typing a question in. While she's doing that, I have a question for you, Justice Fairbanks, if you don't mind. One thing that occurred to me was, I'd read the article, End with the Bear Chasing You, or I forget the name of it, something to that effect, about moving the peacemaking model, using it in state court as opposed to tribal court, which is, I understand, slightly different than what you're saying, which is talking about using peacemaking within the tribal context itself. To use your language, looking within, that shifting and looking within, as opposed to looking out and replicating. I'm wondering if you have had experience, though, with state courts implementing the peacemaking model, and if so, what if any obstacles did you run into, and then what accelerators did you also experience that really kind of made that the adoption of those practices more seamless?
Well, I think that with the Washington model, Tim Connors got the okay from the Chief Justice of Michigan through his state tribal consortium. And we're doing that same thing over here in Oregon, where we're putting together that process. And we've also done it in Texas in terms of working with the Texas Supreme Court Permanent Commission on Children. And so I think it's really through those state tribal consortiums that you can begin sharing ideas. But I think it would be good to have Judge Connors on as one of your speakers, because he really comes at it from a state model. But I'm not talking as a judge right now. I'm talking as a tribal lawyer on a case that I was working on. And really, the tribe and state were coming head to head, and I was representing the tribe, on terminating the parental rights of two parents. And the tribe I was representing, they didn't believe in termination of parental rights. And so the state is breathing down our neck in terms of timelines. And really, these parents really, their rights, to me, they deserve to be terminated. But I was zealously representing a tribe, and as I thought it through, they were not going to agree to any kind of termination. So it was going to have to go into outright litigation. And so I asked permission from the lawyers and the tribe to use peacemaking principles in a family conferencing setting. And so, on some of these difficult cases, there's 7 lawyers, and they're not going to get along, period. And neither are the families. But we were able to convene a peace circle, several sessions. And at the end, we were able to achieve consensus through this family conferencing methodology, using the basket, using the peacemaking principles, using the best interests of the child. The tribe appeared telephonically, And we were able to get an agreement and get that agreement into the court, and the judge made it into a stipulated agreement. So we were able to get the case resolved. We had a stipulated agreement that the state approved as well as the tribe. And interestingly, the two families involved were at each other. But guess what? They decided they were going to share rides to visit the child. And that was big for us. And so that case caused me a lot of heartburn, but I just really had to do something different. And once we did that, and the state was not, the tribe wasn't even open to it, to tell you the truth. Because we have been so used to replicating an adversarial method, okay? So once we were able to do this, especially with our ICWA cases, it really does move toward common ground and really coming up with agreements. I don't know if that kind of helped you understand it a little better.
Yes, it does. Thanks. And Scott, I also appreciate you taking some notes. We have another question that came up in the chat for you, Justice Fairbanks, from Michelle. She asked whether you can tell us more about training for peacemakers in particular.
Well, through the NIJA, the Native American Indian Tribal Court Judges Association, we're doing a lot of training nationally, and through NARF, the Native American Rights Fund. If you click on NARF, the Native American Rights Fund, there's a peacemaking initiative that has some articles, and we have a group there of peacemakers that Brett Shelton has brought together, and we do training throughout the country. In January, I had gone home to Alaska because we're a public law 280 state, and we're looking at peacemaking. And so I'm going to bring a team of peacemakers up to Prince of Wales, hopefully, knock on wood, to really get the community to think about this. The other is in Michigan, or throughout the country, there's these state, tribal, federal consortiums. And through those consortiums, we were able to do a peacemaking training. And so, for example, up in Michigan, I flew up and did this peace presentation, and then we actually went into a peace circle, co-facilitated by another judge and myself. And when I walked into that session, it was federal, state, and tribal judges. I thought, why did I agree to this? Whoa, it was pretty intimidating, but I went forward with it. And I think once we got into the circle and finished the circle, they got it, but it really took a participatory mode to get it across, especially working with ICWA cases like you all work on. And I think the National Council of Family and Juvenile Judges, we're trying to get that more peacemaking onto the training agenda for all the state tribal court judges. And so, for example, Tim Connors, the judge in Michigan who established the Washtenaw, and Brett Shelton from NARF and myself, we presented at the State Tribal Forum in Washington. I did a small presentation in Oregon at the State Tribal presentation, but we really launched what we're calling our resiliency model. We launched that in New Mexico with Beth Gilia, at the Children's Institute. I worked with Beth for a semester, so she's fantastic in terms of bringing new ideas in. And so we launched this concept in New Mexico. And so New Mexico is really considering, I don't know if anyone from New Mexico is on, but I think they're considering looking at this as an option. And we really have a child custody mock peacemaking that we use so the judges and lawyers can participate in an actual peacemaking.
Great. Thanks, Justice Fairbank. Also, I would add that Sarah Jacobs from New Mexico is on the line and actually had a specific question for you about how to frame the peacemaking conversation with the department when there's potential pushback from the agency, concern about duplicating efforts, more demand on caseworkers, and those sorts of issues.
And sorry, Andy, can I ask something in addition to that too, just to clarify for the justice also?
Of course.
We did have a conversation with Judge Connors, which was great and really, really helpful just to sort of start the conversation. And at the follow-up meeting that our Protective Services Subcommittee had about it, we could already tell at that point that people were not going to be on board. And so that's where my sort of question stems from. It was even just in the beginning conversation.
I know that resistance. We all know it. You know, and we experienced it in Indian country. Just because it's an Indian concept, in Indian country, we're used of the adversarial system. So I think that you have to have actual peacemakers there and actual case studies and do an actual mock to really get individuals to understand it. Because when I did that peacemaking I talked about where the tribe and state were at odds, that was in New Mexico. And oh man, did I get the resistance. But the end product was worth it, you know. And so I think especially social workers who are on, you know, they're in the trenches. I think we could, in New Mexico specifically, we can work through the Social Workers Consortium, ICWA Consortium, to really have a session and have some mocks, you know. When we use the system in New Mexico on some really tough cases, boy, our outcome was way better than the adversarial. And in terms of time limitation, when you look at how long a case takes to get through the system, it is terrible in terms of time. So I don't think they're being real practical or accurate in terms of the time. You know, it may initially take some time, but I think it's going to cut back on the court docket and time there. Hello?
Yep, we gotcha. You're breaking up a little bit on my end. I'm not sure if it's true for others as well. I've been having reception problems of my own. But I heard 99% of what you said.
Oh, okay. And I'm going to be back in New Mexico. And so I met with Beth Gilia, and I know Judge Romero from the Children's Court really is a proponent of peace circles, and there are several people willing to look at it. And I think through the State Tribal Consortium and the ICWA Consortium, we can, you know, get some support. And it's got to be an option. You know, I think it gets murky when people think this is the answer to ICWA. No, it's an option. If you want to do the adversarial, fine, you know, but as an option, consider something different, because our ICWA statistics are pretty bad in all the states. And I think with the social workers, we've had to really do a lot of training and cultural literacy training, you know, just to really get at some of the issues. And therefore, through the consortiums, we're able to strengthen the relationships and have some frank discussions rather than end up polarized.
Great. Thank you. What other questions do folks have? We'll give it just a second here. As folks are typing and considering.
Oh, I guess I'm not looking in the right box.
Oh, that's all right. This is a pretty savvy crew. I realize I'm not sure how familiar you are with Adobe Connect, but as you probably can tell, this is a pretty savvy crew, and they move and shake in this space. So there's usually stuff kind of going on.
Pretty good.
Yeah. But I mean, I have to say, you're doing a pretty good job hanging with them. For a group that's as well versed as they are, you're definitely tuned in. So I see Michelle dropped the link to the Michigan discussion, or Michigan peacemaking, I mean. So thanks for that, Michelle. All right. So if we don't have any more specific questions for Justice Fairbanks, although if one comes up, of course, feel free to ask it either in the chat or over the phone. It's fine. We have a few minutes left here, about 3 or 4 minutes left before we move into the Who Needs Help session and then open space. And I'm just curious if anyone in the room has ever used or argued for peacemaking as an active effort. And I mean, obviously, active effort in terms of ICWA requirements. And if so, did it work? What was so great about it? We sort of have a silly question. What cultural connections did it have? I mean, peacemaking itself is sort of culturally rooted. But I'm wondering if there are any active effort specific kinds of arguments, or I guess arguments too adversarial of a term, active efforts kinds of activities related to peacemaking that folks have engaged in their own jurisdiction. And if so, could you speak about them? You can just type it into the chat or say it over the phone. Gotcha. All right. Well, I will take silence as a confession that none of us have done it, or at least an admission that none of us have done it. But that's good, though. I mean, this group kind of prides itself on being innovative. So the fact that you have a lot of people who are really active in promoting ICWA and indigenous rights, that are getting this kind of exposure, that haven't worked with it on their own, is actually really helpful. It's sort of the perfect topic for this group, which is no surprise since it emerged out of this group. All right. So what we'll do next then here, just since I have an eye on the time, is we'll pop over to the Help Wanted session. So at this point, Justice Fairbanks, you're sort of off the hook. We really appreciate your contribution in your work. And to the extent that people have follow-up questions, trust me, we'll funnel them your way if that's okay with you, going forward. So
yeah, that's fine. And thank you very much for inviting me. I appreciate it.
Thank you so much.
Yeah, the honor was ours for sure.
Okay, so, thank you. I'll sign off now.
Okay, thanks again. All right, folks. So now the question is, when do we want to meet next? And then we'll start working on what we want to work on next. So if you'll just respond to the poll in the upper left-hand corner of your screen with some times. I know that everyone's got to get their calendar out and kind of look back and forth. So we'll give it about 3 minutes for people to respond. You can choose as many dates and times as you want. So choose all the ones that work for you. And it's pretty simple, majority rules. Whatever time is best for everyone is the one we'll do. If there's a tie, we'll narrow it down to those and revote. Actually, we've ever had a tie now that I think about it. Maybe once. Good. I see votes are still trickling in, so take your time, line up your calendars, and we'll make a call here in a minute or so. All right. Responses are slowing down a little bit. So let's take about 30 more seconds. If you're looking at your calendar in a fit of hysteria because I'm going too fast, just type into the chat, or something, and I'll slow down. I don't mean to rush, but I don't want to linger too long either. Gotcha. All right. It looks like July 25th from 11:30 to 1 is the winner. We got 7 people voted for that. So that'll be our next meetup. Jill, I see your question. I'll address it in just 1 second. So July 25th, I'm just typing it in from 11:30 to 1 o'clock p.m. That's Eastern time is the next meetup. So, Jill asked the question, how does civil jurisdiction for tribes on reservation in a PL 280 state work as it relates to non-natives living on the reservation? Does that make sense? It does to me, Jill, but do you want to just kind of say it over the phone and explain a little what you mean?
Well, so I have one of the counties in Nebraska that is stating that even though all of the land in that county is either on the Omaha or the Winnebago reservation, that the tribes don't have civil jurisdiction over non-natives living in that county, meaning they don't have the authority to do the child abuse neglect investigations, APS investigations, file those in tribal court if they would choose to do that. I've been doing some research and trying to figure out, but it looks as though the Omaha tribe specifically, there's been a long sort of question about this jurisdictional issue, and I have yet to sort of find a conclusive answer, and I just wondered if anybody on this call would have some insight.
Yeah, it's a great question, so I'll just open it up to the group. Has anyone ever had that kind of issue where jurisdiction has been contested for a non-native who's residing on a reservation? When we're talking about civil jurisdiction in a dependency case, I assume. Sounds like you stumped us, Jill. That's a good one.
Well, that wasn't the answer I wanted, though.
I bet it wasn't. I wonder if, I'm going to just type it into the box up on the top here, and I wonder if we might actually take that up as a question at next month's meetup. Is that too late for a response to be valuable or useful for you?
No, it won't be too late. I'm going to probably still continue to work on it between now and then because I do need to get something figured out. But no, I think that would be useful.
Okay, so we'll bring it to the group. I'm just curious, from as a lawyer, is the line of cases that you've been looking at, first of all, are they on point? And if so, do they distinguish between the sort of the status of the respondent parent as either native or non-native determining jurisdiction, or the location that gave rise to the action? That sort of civil jurisdiction language that we all know.
Well, so interestingly, the tribe doesn't actually file for non-natives in tribal court. They pass those over to the county to file and the HHS in Nebraska to work. But the initial investigation or initial assessment is done by the tribe because of their jurisdiction on reservation.
Okay, so they pass the respondent off to state court, but they still conduct the investigation themselves because it was on the reservation. Is that what I'm hearing you say?
Yes.
Okay. Gotcha. So, in your cases, are you trying to bring the non-native litigant back into the tribe's jurisdiction in tribal court?
No. it's a county issue with the tribes having the county doesn't believe the tribe actually has exclusive jurisdiction for civil matters over non-natives on reservation. That's the main question, I think.
Gotcha. Paulie, I noticed that you typed something in the chat. Can you just say a little bit more on the line about your experience there?
Yeah, so we have our tribal court. Our tribe is like right on the border of Oregon and California, so we get a lot of crazy jurisdictional stuff. But we've had some child custody stuff where a parent has said we don't have civil jurisdiction. And what has typically happened is, one parent will say, oh, it's a state court issue, you don't have jurisdiction, and we'll file in that other court, and it typically results in a bench-to-bench conference between the judges. So we've had a couple jurisdictional issues. One was actually with a court in Pennsylvania. And, we've had a couple within California, both locally and, as far south as San Diego. And every time it's ended up in a bench-to-bench conference, and the judges decided who had jurisdiction.
So does council motion for a bench-to-bench conference, or is that something that the court initiates itself?
The court initiates that itself. If there's a question of jurisdiction, our court administrator reaches out to the court administrator from wherever the jurisdictional question is, and the court requests a bench-to-bench.
Got it. And is that, I'm just interested in that procedure now. So procedurally, does the issue have to be contested, or is it sort of a little slightly looser than that, where it's like a judge saying, does counsel have to brief the judge on the issue and then the judge initiates the conference, or is it sort of just like, hey, I want to talk to this other judge and figure it out?
Usually it's a little bit both. Most of our litigants in court do not have attorneys. And so we'll have, parent A saying, hey, you don't have jurisdiction over me. I'm not native. Or one of my kids is native and the other one isn't. And the judge is like, well, you live on the reservation. We have jurisdiction. Our code is clear. Well, I'm filing in state court. And so the judge says, well, why don't you go ahead and file? And then we'll have a bench-to-bench and decide it. Or the court will say, well, the judges will have a bench-to-bench, and if they think you should file in state court, they'll advise you to do so. So, our judges have a really good relationship, and so they will typically reach out to each other early on. Or if a tribal parent is in state court and says, I've already filed in tribal court, usually the judge will stop the hearing right then and initiate the bench-to-bench.
Interesting. Jill, do you have any follow-up questions, or it may be something that you and Paulie want to discuss even offline?
No, I don't think I have any follow-up questions. The issue that that's really helpful to know, but these are cases that that's not judge to judge that's even looking at the jurisdictional issue. The county attorney and the sheriff that are questioning jurisdiction.
Gotcha.
It might help just from our experience, because we've been doing this for 8 or 10 years. It really is helpful. I know in a couple counties we started with standing orders that both judges issued, and then counties and sheriff's departments had to follow them. At this point, we no longer need a standing order, but that helped because the judges worked it out and then said, here's what we worked out, you guys deal with it.
What was the standing order about, and was it filed then for every case?
It was a standing order of the court, and most of it was about sharing information because county workers were saying they couldn't share information with tribal workers because of confidentiality, even if it was on the reservation. And so the state court judge made a standing order that applied in all dependency cases where an Indian child was involved, that they should be sharing that information with the child's tribe or the tribe where the child was located. And so what that happened is they were coming on the reservation to do emergency investigations without notifying the tribe. And
so if you think about the reverse, where the tribe is conducting the investigations on reservation, but not going to proceed with, like, so maybe they find that case that's unfounded. So there's not really going to be any filing anywhere. That information doesn't necessarily have to go anywhere other than to the tribe, is my understanding, but the county attorney is not happy about that. If that makes sense.
Yeah,
so
sometimes it might help to get the court. In our experience, it's helped to get the judges involved because, like I said, our state court judge and our tribal court judge have a really great relationship. And so they've been able to come to an agreement that compels the county and law enforcement to do what they should do. So I don't know if that would be helpful to you or not.
Okay. Well, it's definitely something to consider. I'm not certain about the relationship tribal court judges with state judges currently, but we're working on that. So thank you very much.
Yep.
Yeah, great. Thanks. All right. So we will revisit this question and check in with you, Jill, next month and kind of see how it goes. Not that you'll have a definitive answer by then, but whatever it is you do learn, we probably could all benefit from. So we'll check in on that. So let me ask this other question then. We know when we're going to meet next. What should we work on? So let's take about 1 minute. And the question is this: does anyone have an ICWA-related project, program, or question that you're wrestling with in your state or tribe that you'd like this group's help working through? If you have a question or issue or program or something you want to run by the group and troubleshoot, just type it into that box, the blank box there in the upper right-hand corner of your screen. So let's set the timer for 1 minute. If you have something, type it in. Ready, set, go. Gotcha. All right. Looks like we have 3 topics that have emerged. So these are the 3 that we'll pick up on next month. So first, we have a question from Nebraska about how to handle reason to know, so the reason to know standard in ICWA cases. So we'll have that question first. Let's see. Let's see. Who was it from Nebraska that wrote that question? I know there's a couple of you on, I think.
It was me. This is Marianne.
Okay, excellent. So, hi, Marianne.
Hi, Andy.
Nice to, yeah, you bet. Nice to hear your voice. So Marianne, if you'll just bring that question to the table next month, we'll take a crack at that. And then we'll also revisit Jill's question about civil jurisdiction. And then who wrote the question about consultation and collaboration?
That was Polly from Tallawadaini Nation. We're just struggling. Counties want to consult with the tribe and trying to help them understand when you use the word consultation, that really is talking about a government-to-government function, and it's not something that our department's going to do with your department. And they don't understand why they're not able just to, talk to our chair. Well, we'll just talk to the chair. And we're like, it doesn't work like that. Would you go talk to the governor of Oregon if you were struggling with? No, you wouldn't. You'd talk to the director. And so I think that's we're just trying to figure out a good way to explain that difference without, frankly, being snotty and, damaging an already tenuous relationship.
Yeah, got it. Okay, good. So we'll plan on, that essentially gives us our 3 creators. And again, being a creator is nothing, earth-shattering. All it means is asking your question to the group, and then I'll facilitate a conversation around its answer. So we have 3 creators, Polly, Marianne, and Jill, for next month. So everyone else in the chat should just sign up for whatever role they want. So we need, a connector. So that's someone that, shares information back and forth throughout the group. I mean, it kind of happens organically in this meetup, when people share, like, for example, links in a chat. But a connector is going to help Polly, Marianne, or Jill share resources with each other. And I'll send you a follow-up email if you decide to be a connector with more specific directions. It takes maybe 15 to 20 minutes over the next month. Carriers transmit out information to the rest of the group after the meetup. Again, that's about a 20-minute ask. You just shoot an email out with a couple links to it. And consumers are people who consume the content, you know, participate, make connections, that sort of thing. So just in the spirit of, you know, this being a group of run by the participants, if you just type into the chat, everybody's got to sign up for one thing. Doesn't matter to me what you sign up for. But just type it in the chat which role you want: consumer, creator, connector, or carrier. So we'll give 1 minute for everybody to do that. And Scott and I are the caretakers, by the way, if you're wondering. Cool. Let's see. Good. All right. Yeah. In between the other three, we should have our bases covered. Excellent. All right. Well, thanks so much. That's perfect. Normally we do an open space, and but we kind of have been having that as we've been going along. But I want to make sure that everybody sees this open space picture so you know where I'm going to be camping this weekend, just to rub it in a little bit. That's Chin's Lake in Colorado. Obviously, I'm stoked about going. So we have about 4 minutes for open space. If you have a question or a comment, something you want to raise to the group, really about anything ICWA related, now is your time. So I'll set the timer for 1 minute, see if anything emerges. If not, then we'll call it a day. So ready, set, go. All right. Looks like we got our bases covered here for our June meetup. So we're in good shape then. So on your way out the door, first of all, thank you, everybody, for showing up and participating. We want to keep checking in each month and making sure that this is a valuable way for us to spend our time, that we're doing what we want to do, and if we're not, to change it. So this is a group that's run by our own agenda and our own structure, however we want to run it. So on your way out the door, if you'll just respond to the poll in the upper right-hand corner, and just kind of rate the meetup we'll check in and make sure it's valuable. If you're not a 6, just take a second to jot down something that we could do, and I mean we as a group, not we as the Center for Courts, but we as a community of practice could do to make the meetup more useful, or to make it better. So if you just type that, if you're not a 6, what can we do to be better? If you're a 6 or 7, you can just put your ranking in there and check out. So thanks, everybody. Really appreciate your participation. And again, thanks to Justice Fairbanks for what I thought was a really compelling presentation. Happy 4th of July and have a great weekend.